This is a student brief of a state animal law case for the state of Georgia for ATE 3515, Legal and Ethical Issues, presented by Brittany Smith. The case I will be presenting is Barton versus the state of Georgia, which is a Supreme Court of Georgia case. This case includes convictions of dogfighting and gambling. I want to point out that according to the United States law, a person commits a crime of dogfighting when he or she allows a dog to fight another dog for sport or gaming purposes. In the case Barton versus the state of Georgia, there were 4 defendants: William Townsend, Marvin Chaffin, James Barton, and William Green. All 4 defendants were arrested after a raid of a farm in Mitchell County, Georgia, where evidence of dogfighting and gambling were discovered. When police raided the farm, several people fled from a pit where 2 bloody and wounded pit bull terriers were found. Upon approach, officers heard at least one person say, "I'll put 5 on that." There were also several other pit bull terriers tied near the area, along with decaying carcasses of dead animals that were tied to devices used to train dogs for dogfighting. William Green, a resident of Hollywood, South Carolina, was apprehended while standing next to the pit with $899 on his person. Chaffin, Barton, and Townsend were apprehended away from the dog pit but brought back to be searched. They were found to have a large sum of money on them also. All 4 defendants were convicted of crimes of dogfighting and gambling. The defendants appealed the ruling because although there was sufficient evidence of dogfighting and gambling, there was not enough evidence to link them to the dogfighting and gambling and support their convictions. The issue at hand and the reason for the appeal is, did the state of Georgia have sufficient evidence to convict each defendant, William Green, William Townsend, Marvin Chaffin, and James Barton, of dogfighting and gambling? The court made a ruling on the case on October 31st, 1984, and it was decided that the conviction of one of the defendants be affirmed, while the convictions of the other 3 defendants be reversed. The reasoning and rationale behind the court's ruling is as follows. First, the state presented evidence that was sufficient to conclude that dogfighting and gambling were taking place at the farm in Mitchell County, Georgia. And this is the place where the 4 defendants were apprehended on October 8, 1983. Second, there was also sufficient circumstantial evidence presented by the state of Georgia to convict Green of dogfighting and gambling. First, he was 400 miles from his home, down a dirt road, shortly after dawn, in an area known for dogfighting and gambling. He was found standing directly next to the pit where two pit bulls that were bloody and wounded had obviously been fighting. Green also had $899 on his person. It is difficult to prove his actual participation in the activities. However, the court used ruling from a United States Supreme Court case in 1965 called United States v. Gainey to prove circumstantial evidence. In this ruling, it was found constitutionally acceptable and rational to draw a conclusion of guilt of the crime of carrying on the business of a distiller from the accused's presence at the site of the distiller's business. By using this ruling of the United States v. Gainey, the Supreme Court of Georgia concluded Green guilty beyond a reasonable doubt of dogfighting and gambling because he was at the location where such activities took place. The third reasoning and rationale of this case was that the court found there was not enough evidence to convict the other three defendants, Barton, Chapin, and Townsend. The state had no evidence that these three men were at the site of the dogfighting and gambling. There were 8 officers at the raid, none of which could positively identify the 3 defendants as being present at the dog pit at the time of the raid. The only evidence that the state offered was that the 3 men were apprehended from an undetermined area and brought back to the dog pit by an unidentified officer for search. Even though they had large sums of money on them, no evidence linked them to the area where the gambling was taking place. Therefore, the evidence is insufficient to convict the defendants, and the convictions were reversed. All of the judges on the Supreme Court of Georgia concurred with this ruling, so there is no dissenting opinion. The final disposition is that the Supreme Court of Georgia affirmed the lower court's conviction of William Green due to sufficient evidence linking him to dogfighting and gambling. The Supreme Court of Georgia reversed the convictions of William Townsend, Marvin Chapin, and James Barton due to insufficient evidence linking them to dogfighting and gambling. I agree with the Supreme Court of Georgia's ruling based on the evidence presented. Green was found next to the dogfighting pit with a substantial amount of money on his person, which to me links him to the scene of activity. I also agree that the state did not produce enough evidence to link Townsend, Chapin, and Barton to the scene of dogfighting. Even though it is likely they fled when officers arrived, there were no officers that could positively identify them as being at the scene. Therefore, there is no evidence to convict them of such a crime. Unfortunately, the convictions of the lower court were reversed by the Supreme Court of Georgia for these 3 defendants, and in turn, these 3 defendants probably continued to attend dogfights. The references that were used were retrieved from Michigan University's Animal Legal and Historical Center.